What exactly is going on with regards to the sale of PHB? Did the court issue an order to halt the sale, or is it just a notice order to the CBN?
The court didn't actually issue an injunction. The parties that went to court, the aggrieved shareholders, approached the court ex parte, that is without the CBN or its lawyers being present, and wanted an injunction to stop the sale. The court asked that the CBN and the other parties and all those involved in the transaction be put on notice and fix the date for that matter to be argued. So yes, the court did not explicitly issue an ex parte injunction against stopping the sale. However, my view is that the legal effect, once the CBN and all the parties are put on notice, is that they can't proceed with that transaction until the application for injunction is disposed of.
What does it mean to put the CBN on notice?
Well, the court wants them to be served. They want all the parties to be served and all of them to come to court, argue their position before it makes the decision as to whether an injunction is properly should be granted or not. What the lawyers to the aggrieved shareholders had wanted, based on some argument that there was some urgency, was that the order should be given in the interim before the CBN and other parties were called to court.
Let's talk about the shareholders and why it is that they're reticent to have PHB sold off to Habib Bank of Pakistan.
Okay, you know that the PHB was made up of two institutions. It was the result of a merger itself between the old Habib Bank and Platinum Bank, which was a newer bank, a local bank. But at the end of the merger, I think the one of the parties got the upper hand and took over management. I think that there are some legacy arguments. So my suspicion is that is one wing of the old legacy bank, probably the Platinum wing, that is in court because it's not satisfied probably with the way the shares or the powers in the new entity are being distributed.
Now, obviously, moving beyond PHB, this issue is not peculiar to this particular transaction. Just at the weekend, the Nigerian Tribune reported that the Proactive Shareholders Association has met, and a lot of shareholders of rescued banks across the board have been devising strategies of resistance against the sale of some of these rescued banks. How's that going to imperil the entire process, if at all?
I have always believed, and I've argued, and is on the public record, probably also on CNBC, that you need the shareholders' involvement in doing these sales. I do not know of any legal process that allows regulators or any other parties to dispose of any type of asset without the involvement or consent of the owners. Now, you're going to have those who are unhappy with this transaction for different reasons, and I've always felt that in the wider interest of the system, it was prudent to involve them and see whether we could work out from the beginning, some arrangement that would be acceptable to at least the majority, overwhelming majority of the shareholders.
What do you mean to involve them? Because apparently it's the boards of these banks making the decision. It's not the CBN doing so. So the board surely can't act without consultation with shareholders.
The boards are supposed to act on the basis of extraordinary general meetings, shareholder approvals and stuff. The laws protect minority shareholders. The boards may not adequately represent some minorities, or even on the board, some directors may have been outvoted because you need a majority on the board. So at the end of the day, I thought, and I still believe, that involvement of critical shareholder groups, even in a consultative manner, proactively throughout the process, would save us all these legal proceedings.